Good afternoon. Welcome to the Say No to Judicial Gerrymandering, a town hall on judicial districts. I'm Terrie Griffin, president of the League of Women Voters of Pennsylvania. We are a century-old nonpartisan organization begun in 1920 to register, educate, and encourage women voters after passage of the 19th Amendment acknowledging women's right to vote. We definitely are here for a very serious purpose, but at this moment, I would just like to pause and ask us to take a moment of silence as our democracy is under attack. This is something that I feel necessary and we need to do for just a moment. Thank you. Regarding the League of Women Voters of Pennsylvania, in the years since the passage of the 19th Amendment, the League has consistently advocated for fair elections, fair representation, and strong checks and balances to preserve our essential rights. Since 1949, the League of Women Voters of Pennsylvania has advocated for an end to partisan judicial elections here in Pennsylvania. Over the last 7 decades, the League has worked to free our highest courts from partisan influence and the corrupting power of partisan campaign funding. Merit selection bills the League has supported have sometimes been given a vote in committee, sometimes even passed in one house or the other, but never been given a final vote. Since 1990, the League of Women Voters of Pennsylvania has also advocated for an end to partisan gerrymandering of Pennsylvania's legislative districts. Bills the League has supported have rarely been given a vote in committee in the Senate, and as far as our records show, have never been given any vote at all in the House committees, despite strong bipartisan support. The League has also advocated for years for changes to legislative procedures. We arrive at our position by study and consensus. According to that process, the League of Women Voters of Pennsylvania support changes in the rules of procedure that would, 1, encourage the use of joint hearings, and 2, provide for automatic calendar ensuring bills are given a vote. We also support changes to ensure advertising of public meetings in a timely manner and more consistent enforcement of rules for open committee meetings and public reports. This issue of judicial districts falls at the intersection of those areas of concern. The bill would further publicize our highest courts, undermine constitutional checks and balances, and expand opportunities for gerrymandering. It was passed in the last session without transparency, accountability, or respect for legitimate public concerns. Our highest courts have long been essential guardians in the fight against voter suppression. The Judicial District Bill is an attempt to undermine that role. We oppose the bill and object to procedural rules that allow that bill a vote while denying a vote for so many far better bills with far more public support. I'm happy to introduce Carol. I'm happy to present, Carol Kuniholm to explain the bill and tell you more about how to oppose it. Carol is our Vice President of Government and Social Policy for the League of Women Voters of Pennsylvania, and in that capacity helped launch Fair Districts PA just 5 years ago this month. Fair Districts PA is an initiative of the League of Women Voters of Pennsylvania and a participant in the National League of Women Voters People-Powered Fair Maps Initiative. Following Carol's presentation, Fair Districts PA Legislative Director Pat Beaty will lead a panel discussion with Debbie Gross, President of Pennsylvanians for Modern Courts, and Judge Lauren Stengel, board member of Pennsylvania for Modern Courts and recently retired Chief Judge for the United States District Court for the Eastern District of Pennsylvania. Thank you for joining us and for your concern for protection of rights for every Pennsylvania. Carol?
Thank you so much, Terrie, for doing our introduction. And thank you to all who are here today. We know it is a historic day. We know there's a lot going on. Some of our folks said no one was going to show up, but we have about 500 people here with us already. We had about 1,500 register for this. We have about 500 attending right now, and we are also live streaming on Facebook. So thank you for caring about this. You show that this is an important issue. You also show that Pennsylvanians care about our democracy, care about structural change, and are willing to do the work to understand and to make these things happen. So thank you. I'm going to go ahead and share my screen and do explain. We're going to do a presentation. And as Terrie said, after the presentation, Pat Beaty will lead a panel with some discussion. So I'd like you to think about this as a story of two very different constitutional amendments, two different kinds of gerrymandering, and a potential new low in the history of our state legislature. When you think about advocacy or letters to the editor or follow up with relationships with legislators or their policy staff, think about this bill we're going to discuss today as Exhibit A in the tight knot of dysfunction that makes reform in Pennsylvania so very, very, very difficult. Fair Districts PA was formed in January 2016 by the League of Women Voters of Pennsylvania and other organizations to address gerrymandering, which, as you know, if you've been following us at all, is the manipulation of electoral maps for political advantage. The word has been around since Massachusetts Governor Elbridge Gerry signed off on a map with the district shaped like a salamander back in 1812. We know gerrymandering of congressional districts, as well as of House and Senate districts, has been a problem in our Commonwealth for a long time. And we know the League has been speaking out about it since 1990 and other organizations as well. We know that new technologies have made it far worse in the last few decades. We've seen this graphic many times before. And we also know, without question, the people of Pennsylvania do not like gerrymandering. There were surveys in 2019, one done by Franklin and Marshall found that 72% of voters think gerrymandering lets party leaders put party interests ahead of voters' interests. And we see that played out in many ways. They believe gerrymandering creates polarization and gridlock, allows elected officials to choose their own voters, gives voters less choice on election day, and prevents voters from holding their representatives accountable. And again, we're seeing that played out with representatives who are not accountable to voters and not accountable to much. And this is a problem here in Pennsylvania and right now across the country. We know that 67% of Pennsylvania registered voters in that poll, and in many other polls, the numbers are almost exactly the same. About 2/3 of voters in Pennsylvania and across the country support an independent commission to draw state legislative districts. And we know that about the same number, about 1 out of 5 think that legislators, less than 1 out of 5 think that legislators should be the ones who are allowed to draw those district lines. So for almost 5 years, we've been working on reforming our state constitution to create an independent Citizens Redistricting Commission. And that had broad bipartisan support in the past session and in the session before. More co-sponsors than any others in the House, 110 co-sponsors in the 2017-2018 session, with 39 Republicans and 71 Democrats. That's pretty strong bipartisan support. And again, more than any in the House in that session, and more than a majority had signed on to that bill. There were resolutions of support, resolutions of support for an independent commission from 24 counties and over 360 municipalities, over 100,000 petition signatures, over 500 supportive letters and op-eds from across the state, more than 900 public meetings attended by over 33,000 people. And none of that mattered. In fact, legislative leaders said, well, it doesn't matter. It doesn't matter how many co-sponsors you have. It doesn't matter about those resolutions, petitions, doesn't matter. None of it mattered. We had many, many, many meetings with legislators themselves, many, many emails, many phone calls, meetings with legislative staff. And we had one of the largest rallies in Harrisburg in recent memory. None of it mattered. The supported bills were never given a final vote. And yet there's another bill, Judicial District Bill 196, House Bill 196, in the last session sailed right through. It was introduced in January 2019. It was voted out of the House Judiciary Committee on April 30th in 2019, and we cannot find a transcript of that committee meeting. We can find the record of votes, but we can't find record of the discussion on the General Assembly website. It was passed out of the House on December 2019. It was voted out of the Senate State Government Committee on July 13th, 2020. And we did find the live stream of that voting meeting. It was a meeting with 4 or 5 other bills as well. It was a committee meeting called from the floor, so it was not even scheduled in a room beforehand. And the time spent on House Bill 196 was 9 minutes. And that includes the time to describe the bill, discuss the bill, and tally the vote. It passed out of the Senate 2 days later, July 15th, 2020. Officially, that's 3 days later. You have to count July 13th as the first day, July 14th, and July 15th. But it passed very quickly with no expert testimony, no public input, no cross-partisan support of any kind. So 2 different constitutional amendments. This is a constitutional amendment, the redistricting reform bills, constitutional amendments. The ones sought by the public were blocked repeatedly. The one that came out of nowhere, like a pirate ship sailing across the seas, moved forward very fast. So what does House Bill 196, the Judicial District Bill, do? It's a constitutional amendment that organizes the judiciary into representative districts and further provides for residency requirements. That is the summary that was included with the bill in the last session. Now, already you can see there's a problem because the judiciary is not actually supposed to be representative. And so that language suggests a misunderstanding of what the court is meant to do. Why was this bill introduced? According to the prime sponsor, Representative Russ Diamond, there are different philosophies on how to apply the law based on how and where you grew up, to which many in the legal world say, really? I mean, there are every lawyer, every attorney, every judge has a different philosophy. And some of those have to do with where they grew up. And some of them have to do with where they were educated. And some of them have to do with all kinds of things. But the idea that they need to be tied to a region is a little puzzling. But I want to step back and think about what do the courts do and why does this matter so much? So there's 3 branches of government. You learned this in high school civics class. Quick reminder, there's the executive branch, which is the governor in Pennsylvania. Nationally, the executive branch is the president, and we're seeing some drama surrounding that. But here in Pennsylvania, the executive branch is the governor, and then all state law enforcement and all the administrative entities, all the agencies that are connected with the governor's office. The legislative branch is the legislature. That's the state house and the state senate. They create statutes, they create bills, and that's the part of our government that is elected to represent us specifically. The judicial branch, that's the Supreme Court and all state courts, is meant to interpret and apply the law. And in Pennsylvania, there are numerous courts, and we'll start at the bottom: courts of limited jurisdiction, magisterial district courts, Philadelphia Municipal Court. There's a series of courts. Those are all elected in Pennsylvania from very local elections. The next layer is the courts of common pleas, and that is elected in 16 regional districts. And then appeals from those courts move on up to the appellate courts. And those are the ones that are of interest in this particular bill. There's 3 appellate courts in Pennsylvania. They're also called the high courts or courts of appeal. So if you hear people talking about the high courts, appellate courts, courts of appeal, these are the 3 courts that they're talking about: the Pennsylvania Supreme Court, the Superior Court, and the Commonwealth Court. So focusing in a little bit more on those, there are 15 judges in Superior Court, 9 in the Commonwealth Court, 7 in the Supreme Court, and both the Superior Court and Commonwealth Court hear appeals coming from the Commonwealth Court hears cases that are addressed to the state, to the state or to state agencies. The Superior Court hears appeals coming up from the courts below, and we'll have a couple who are attorneys on the panel, and they can fine tune this if you want to hear more. But the Supreme Court is where the appeals from those two courts go. The Commonwealth Court, 9 judges from across the state, but they hear cases in groups of 3, and there's 3 in Philadelphia, Allegheny County, Pittsburgh, and Harrisburg. Superior Court has 15 judges. Again, they hear cases in groups of 3. The Supreme Court always hears cases in the whole court assembles together and hears cases as a unified whole. And those judges are elected in statewide partisan elections. And that's where this bill comes in. What this bill proposes to do is to take those judges and elect them from districts drawn across the state. So there would be 9 districts for a Commonwealth Court, and there would be 9 separate elections, 15 districts for Superior Court, and 7 districts for Supreme Court. I should also mention these justices are elected for 10-year terms, and at the end of 10 years, then they stand for reaffirmation. They have a vote to retain them or to not retain them. But each judge is elected for a 10-year term. So the idea is that they would be elected in districts rather than statewide. And so the question is this a good bill? Bar associations and good government groups agree it is not a good bill. In fact, they say it's a very, very bad bill. And what it does is it allows the legislature to put their finger on the courts, to weigh in on do the courts meet the requirements of the legislature. In a sense, makes the court answerable to the legislature. Now, how is it that happens? Well, the bill as written would subject the appellate courts to undue influence by the General Assembly. They would undermine the American system of checks and balances between the 3 equal branches of government. And we've seen how drawing districts allows a level of control. And what we would see with our courts was that this would be a radical and dangerous idea of letting the legislative branch take more authority over the judicial districts and undermine the system of checks and balances that currently exist. The bill would, as I said, subject appellate courts to undue influence, undermine checks and balances, emphasize a judge's location over the judge's qualifications. And here's the piece that is really troubling to us. It allows legislative leaders to gerrymander judicial districts. So we've seen what happens when a few people are able to draw districts to give themselves control, to give themselves power, to kind of consolidate their power over other people. The same partisan behind the scenes team that brought us goofy kicking Donald Duck, the old Congressional District 7, that same process, the same process that draws our congressional districts would be the one that would bring us the judicial districts. Now that process, for those who are not deep into this, we have 2 different processes in Pennsylvania. We have a legislative reapportionment commission that draws the lines for state house and state senate. The legislature as a whole supposedly draws the map for our congressional districts, and that same process would be used to draw the judicial districts. What we know is that a few behind the scenes players use all the latest technology, all the latest mapping information, all the latest data about how people vote, and they're the ones who draw our congressional districts. They would also be the ones who would be drawing these judicial districts and could draw them to give an advantage to the party that is drawing those districts. The bill gives no safeguards at all against partisan gerrymandering. What's the rationale for the bill? Now, this is a constitutional amendment, so you'd think there would be a very strong, very compelling, very insistent rationale for this bill. The rationale that's given is that it would ensure diversity. Some legislators say this would provide for greater diversity on our appellate courts. Not really. Right now, there's an almost even party split, 16 Rs, 14 Ds, 1 vacancy. That seems pretty evenly split. 3 of the 7 Supreme Court judges are female, 6 of 9 Commonwealth Court judges, 11 of 15 Superior Court judges. Interesting diversity there. The regional diversity is the one that they talk about. And we've seen statistics saying that a certain number of judges are from Philadelphia and Allegheny County, and it's too high a number given the population of the state. When we start trying to tease out the reality of that, though, is we find that there are judges from all parts of the state, from Tioga and Lawrence and Beaver and Cumberland and Dauphin and Schuylkill, Northampton, Somerset, Westmoreland. When you try to figure out where they're born, where they went to school, where they first practiced law, I think we're missing some because we don't have the full bio of every judge. But from what we can tell, the population of the state, 22% of the population of the state lives in Philadelphia or Allegheny counties. 30% of the population of the state has, as far as we can tell, no ties to other counties, but 70% of our appellate judges do have ties to other counties, were born in other counties, grew up in other counties, or practice law, or even still live in other counties. So there's not a huge divergence between the population and the appellate court, the appellate judges from those areas. And we would say that doesn't seem to be a problem. What does seem to be a problem, though, when you look into it a bit deeper, is if you're concerned about diversity, there's almost no racial diversity in Pennsylvania's higher courts, with just one African-American woman and no men of color. And if you look at the population data, less than 4% Pennsylvania appellate judges are of color, and almost 15%, almost 25% of the population is of color. So that's a huge divergence and a real lack in terms of diversity. Would this bill address that? Not really. It really is not intended to fix that. That's not what it would fix. And it does very little to accomplish that. If diversity is really genuinely the goal, there are certainly better ways to get there. One of the other things the legislators say is, well, we should let the people of Pennsylvania decide. So it's not that we're saying this is better than what we have. We're just going to send it to the people of Pennsylvania in a referendum and let them decide what they want to do with it. Well, what we know is that referendums usually, people often vote yes on referendums because they think the legislature has done their work and given them a good idea. And the reality is we have asked to let our voices be known on referendum on many issues that have never made it through the Pennsylvania legislature. In particular, we've been asking for years now to have our legislature give us the chance to make our voices heard on an independent redistricting commission. And the same legislators who say, well, let's let the people decide on judicial districts are blocking every chance for a vote on redistricting reform. So the judicial district bill also leaves some really important questions unanswered. How would the transition be handled? So if there are numerous judges right now who are drawn into the same district, which would certainly be possible, what happens to those judges? Who decides which of them are able to stand for retention and which of them not? Do they end up running against each other? There's no indication in the bill that this even crossed the minds of those who drafted the bill. What happens when judges from the same court end up in the same district? Can legislators decide which judges can continue in a district and which can't? Can legislators use the bill to remove or punish individual justices for decisions legislators don't like? And we know recently there have been a number of decisions that some of our legislators don't like. And this bill seems very much to have been prompted by the thought of, wouldn't it be great to get rid of some of those judges who, for instance, found against the legislature on congressional districts or other issues that have come up recently. This bill, from what we can see, is sloppy, hasty, and poorly drafted, or it was intentionally written to leave those questions unanswered. So how many other states do this? The answer is none. Most states have nonpartisan judicial elections or a merit-based selection process. 9 states have partisan elections for appellate courts. Just 6 of those have partisan elections for all appellate courts. And only 2 states, Illinois and Louisiana, have partisan district elections for appellate courts. That is partisan district elections. So the others have partisan elections. The only 2 that have partisan district elections are Illinois and Louisiana. And those districts are written into law and rarely redrawn and hard to redraw. So in Illinois, those districts have been in place for 50 years. In Louisiana, the bill that puts those districts in place was written in 1999, and it requires a 2/3 vote from the legislature to even begin to redraw those districts. So with this amendment, the Pennsylvania legislature is proposing an all-new form of gerrymandering in a new historic low. No other state is doing this. Is there opposition to this bill? You better believe it. There is plenty of opposition to the bill. And yet there was no formal testimony invited. There was no formal testimony posted in the General Assembly website or substantively addressed in any hearings or debates. The Pennsylvania Bar Association sent letters to the Senate State Government Committee. Those never made it onto any General Assembly website, but their points are worth pausing on. The Pennsylvania Bar Association says a judiciary which possesses institutional and decisional independence, removed from influences of the political process, is central to the success of a Republican form of government. Electing judges by individual district is contrary to one of the key purposes of a statewide appellate court, which is to render decisions that have statewide impact. Judges should not have constituencies. They should only have litigants before them that expect them to apply the law without bias or other considerations. The Philadelphia Bar Association and other legal organizations weighed in, as did Committee of 70, Common Cause Pennsylvania, and Pennsylvanians for Modern Courts. Were any concerns and objections answered? No. The total time spent on this constitutional amendment in any public legislative setting, from what we can tell on the General Assembly website, less than an hour total. Questions weren't answered, objections were not responded to, amendments were blocked. So who decided that House Bill 196 would move quickly and FDPA supported bills would never get a vote? Was it committee chairs? Was it the majority leaders, the House Speaker, the Senate President pro tem? They will point in different directions. They will say our committee didn't want it, or they'll say there wasn't support, or they won't answer. And what we would say is transparency, accountability, there is none, and no representation at all in the way that this plays out. So why is that? Well, we've talked quite a bit in recent days about the Pennsylvania rules, the House and Senate rules, and those were given a vote just yesterday, and the same rules are in place. Pennsylvania has an agenda fairness score in our state legislature of 0. That means there are no policies in place in the Pennsylvania legislature to ensure that bills with strong bipartisan support will get a vote, or to ensure that all of our legislators have some say in what bills move forward. A few partisan gatekeepers can block bills with strong public support, like redistricting reform, or they can push through partisan bills with no public support at all, like the Judicial Districts bill. So what happens next? Well, one thing is we've learned that there is a bill number, House Bill 38. It's no longer 196 in this new session. It gets a lower number, House Bill 38. The bill could move very quickly in both houses, then go to referendum in May. That seems to be the plan. For what we've heard, the caucuses have already decided, the Republican caucuses have already decided this bill is going to move forward. It doesn't really matter what the minority thinks. This bill is going to move. Most bills that go to voter referendum win. I know that there will be a big fight to educate voters about this, but in reality, the numbers say that bills that go to referendum win. This would go to referendum in the primary in May. That's a different kind of voter that goes, and independent voters aren't allowed to go to vote. Well, they are allowed to vote. They often don't know what's happening. Certainly, there'll be a lot of voter education surrounding this if the bill does move. Voters assume, though, that their legislators did due diligence in putting the bill on the ballot, and they often vote for it. Our legislators did not do due diligence on this bill, and they are hoping that we won't notice. We want to make as clear as we can in every way we can that we notice. So the bill, as I said, has a co-sponsored memo out. It has now been given a number. It has 33 names on the bill so far. What are we going to do about it? Well, citizenship is a contact sport. So we're asking people to call, write, visit legislators to say, don't support this bill. We're asking people to join Fair Districts PA groups or local leagues to learn more and learn how to visit with and advocate with their legislators. We're encouraging people to write letters to the editor saying we need better legislative rules and we do not need judicial districts. The people of Pennsylvania want less gerrymandering, not more gerrymandering. And we have a great speakers bureau. We encourage you to host an FDPA speaker for your organization or faith community. We need to let people know that this is happening. We need to help them understand why this matters. And you can find information on the fairdistrictspa.com website. Look for updates, say no to judicial gerrymandering, and Pennsylvanians for Modern Courts, pmconline.org. If you scroll down the homepage, you will come across links to more information. You will also come across some take action links. So there's plenty of information online to help you in the fight against this. Our legislators have proven they can't be trusted to draw their own district maps. So why would we trust them to draw maps for our judiciary? We are doing everything that we can to say no and to encourage our legislators to say no to judicial gerrymandering. We're going to go now to a panel discussion. Pat Beaty, our legislative director, is going to introduce himself, and then he will introduce our panelists. We will be looking at the questions that you've asked, and thank you for, I see that there are quite a few questions in the Q&A. Please do go ahead now and ask questions throughout the panel. You can also vote vote questions up and down. So if you want, while we're going through the panelists, if you want to take a look at those questions and put a vote, I think that you can vote them up and down. I'll have to check the settings, but we will be looking at those questions after the panelists give you an introduction. After Pat gives you an introduction and the panelists speak a little bit. Thank you so very much for being here.
Okay, thank you, Carol. Thank you very much. As Carol mentioned, I'm Pat Beaty. I'm the legislative director for Fair Districts PA. I have been in that role since early in 2017. I'm a semi-retired attorney after a career in various legal and policy positions, both in state government and also in private practice. Relevant to today's discussion, my legal career started as counsel to the Pennsylvania State Senate Judiciary Committee, where I dealt with several bills affecting our court system and proposals to change the way judges are selected. I also served as legislative counsel to former Governor Bob Casey and was responsible for drafting bills to implement his legislative priorities, including public financing of judicial campaigns, which unfortunately was never approved by the General Assembly. Today's town hall is being co-sponsored by Pennsylvanians for Modern Courts and its new president and CEO, Deborah Gross. Debbie joined PMC in 2020 after 35 years of private legal practice in federal and state courts across the country, concentrating on complex commercial litigation. She was also chancellor of the Philadelphia Bar Association and used that leadership position to stress the importance of an independent judiciary as the cornerstone of our democracy. Debbie is also an adjunct professor at Villanova University School of Law and has served on the boards of several nonprofit organizations. We're also honored to have Judge Lawrence Stengel join our panel today. Judge Stengel is the former chief judge for the United States District Court for the Eastern District of Pennsylvania. He's currently a shareholder with the Lancaster firm of Saxton and Stump and focuses his practice on internal investigations, arbitrations, and mediations. His distinguished judicial career started in 1990 when he was appointed by Governor Casey to a vacancy on the Lancaster County Court of Common Pleas. Coincidentally, I was working for Governor Casey at that time. I don't think that we actually met. I don't recall whether we did or not, but coincidentally, 1990 was also the year when the Pennsylvania Senate, in a bipartisan vote, rejected a proposed constitutional amendment to create regional judicial districts. So here we are 30 years later, dealing with the same issue and the possibility that this time it will pass and go before the voters. Our panel will discuss what that could mean for the independence of the judiciary and other implications for our system of justice. We're going to start with Debbie Gross, who will give her perspective, and then Judge Stengel, at the end of which we will I will moderate the discussion of questions. I will toss some questions of my own to the panelists, and we'll also receive some from the folks who are participating. So thank you all very much for joining with us, and I'll turn it over to Debbie.
Thank you, Pat and Carol, for the extremely detailed and informative presentation. And thank you for inviting Pennsylvanians for Modern Courts to this town hall. PMC was established about 30 years ago as a result of a 1988 report from the Pennsylvania Judicial Reform Commission, which was a commission comprised of legal professionals, members of the judiciary, PMC, honorary board member, and former Superior Court Judge Phyllis Beck. The panel discovered that confidence in the judiciary was appallingly low, and in large part due to the system of electing judges and the fundraising that goes along with it. So this electing judges, politically electing judges, right, along with several scandals in the late 1980s involving Pennsylvania judges, led our founders to determine that a nonprofit, nonpartisan organization was needed to fill the vacuum of judicial oversight and be a herald for judicial ethics. So since its inception, PMC has vigorously advocated for a number of judicial reforms, the merit selection of appellate judges, the most noteworthy among them. PMC continues to push for the selection of competent jurists based on merit rather than through partisan political elections. And the effort to select judges based on merits had actually gained traction and was sponsored in bipartisan legislation through House Bill 111 just in 2018. It had been over the years and repeatedly, I will say, introduced and brought up, but it was actually gaining traction finally in 2018 to 2019, and it was abruptly halted by this judicial redistricting bill. And Carol was not kidding when she described the speed with which this bill was passed. It was like, she used the metaphor of a pirate ship. I actually would say it was a train heading out of the station down a hill without any brakes. The bill, as you know, went through the House in 2019. The members of the House who were co-sponsors for the merit selection bill weren't even aware that this judicial redistricting bill was going to be voted on in the Senate. When I spoke to this all occurred in the Senate in July. I actually just started this job in July. That first week that I started was the week that this sailed through the station, I will say. And when I spoke to some of the representatives who were co-sponsors for the merit bill, but also did support this judicial redistricting bill, and asked them how you justify this, how you explain the two together, they said, oh, they know the bill was bad, but don't worry, it'll die on the vine in November because the elections will change things. Well, as we know, unfortunately, there was not a change in the House. So I have subsequently reached out to those same individuals who said, don't worry, it will die in the referendum. But again, as Carol has noticed and noted, we can't really trust a bill that these legislators themselves admit is bad die in a referendum when Pennsylvania, unfortunately, has a record of voting yes for referendums, and also with respect to the timing, putting this referendum on a primary ballot when we know a lot of individuals don't go and vote. So, you know, it is crucial, and Pennsylvanians for Modern Courts truly believes it. It's crucial that we in Pennsylvania have confidence in our courts, and the politics, favoritism, and money do not and cannot influence decisions rendered by our courts. The appellate courts in our state, for the most part, hear appeals from decisions made by the lower courts. These judges interpret the case law, Pennsylvania statutes, Pennsylvania Constitution on a statewide basis without being influenced by local interests. Their role is to apply the law equally for all residents. They aren't advocates for one side or another. As Carol said, we currently have the opportunity to vote for all 7 Supreme Court judges when the positions open up or when they're up for retention. We similarly have the opportunity to vote for all 15 Superior Court judges when this position opens up or they're up for retention. What this bill will do is say that each of us can only vote for one Supreme Court judge, one Superior Court judge, and one Commonwealth Court judge. This bill would take away our right to elect all the judges on the appellate courts. Therefore, each judge on the appellate court would be more concerned, or could be more concerned, with satisfying and being responsible to their local constituency, addressing issues of local concern as opposed to issues of statewide concern. We would now be making our judges responsible to the localities, similar to what we expect of our politicians. When I spoke with one former appellate court judge, who shall go unnamed, their concern with this responsibility to constituency was that it could result in trading of cases and rulings in the time period leading up to voting on the retention. The Brennan Center out of NYU has documented that judges up for elections render harsher or more severe criminal decisions in the year prior to the retention elections. So you need to understand that this bill did arise out of the General Assembly's displeasure with the rulings by the Supreme Court. There was a parallel resolution that was brought up at the same time with respect to impeaching one of the justices. The focus, as Carol mentioned, the current Supreme Court has a 5-2 Democratic domination. However, this is rare and in essence is one of the first times in this court's history. In 2015, it came about because in 2015, there were 3 vacant seats on the Supreme Court, and they were all won by Democratic judges on the Democratic ticket. However, in 2017, the one seat that was up for election was won by a Republican. And so you all know, there will be a seat up for election in this calendar year, 2021. The other important thing for you to understand is, again, as Carol said, the explanation in this bill as to implementation is just not there. It doesn't set forth the process about how the bill should be implemented. Are the current judges all going to be let go at the same time? Are they all going to be replaced? Are they going to be let go in a rotating basis when they're up for retention election? They have a right under law right now to run for retention election. Is that going to be pulled out from under them? Is the redistricting going to occur first in the Supreme Court, then let it play out among all 7 seats, then the Superior Court, then the Commonwealth Court? There is just absolutely nothing written into this bill to explain the process. While this is all going on, there's also nothing to explain the expense of this process. There will be litigation should it pass the legislature, throughout, challenging it before it gets on the ballot, after it gets on the ballot, challenging it when it's being implemented. So these are all matters that have not yet been considered, but again, as Carol says, we need you to be aware of them there and be educated and reach out to people around you and tell them as well. Pat?
Okay, thank you, Debbie. As I say, we will be having questions at the end of both of the presentations, so I'll now turn it over to Judge Stengel. Thank you.
Thanks, Pat, and thanks, Debbie. I've been on the board of Pennsylvanians for Modern Courts for a little over 2 years. Debbie is our new CEO and doing just an amazing job. I don't know if she thought she'd be as busy as she is, but she's very busy and doing a very good job. We have an excellent board, very representative of attorneys around the Commonwealth. And And Pat, I don't know that we did cross paths, but I well remember 1990 being nominated by Governor Casey, and then I went through the Senate confirmation process. I essentially did whatever Senator Noah Wenger and Senator Gib Armstrong told me to do. And one final introductory note, I was on a Zoom call earlier today and someone asked me if I was wearing a robe, which I found to be disturbing on several levels, that I might be sitting in my basement in a robe. This is a V-neck sweater. My robes have been given away. So that's, I'm very honored to be invited to join this discussion today. And I think I bring a perspective about the judicial selection process, given that I have been through the rarely used, or not often used, appointment process in the state court when there's a vacancy in a state court position, whether it's a county court of common pleas or one of the appellate courts. The governor has the option to appoint, and sometimes that happens and sometimes it doesn't, but I was fortunate enough to be appointed, and then I had to run in the next election cycle. So I ran in 1991 in Lancaster County, and then had to run for retention. Carol mentioned that process in her excellent presentation. And then in 2004, or 2003 rather, I was nominated by President Bush, and then went through the federal nomination process. So I've been through a partisan election process, a retention process, and two merit selection processes, and I have a very strong belief that the best way to achieve all of those goals that Carol talked about in her presentation for our judiciary, diversity and talent and experience, is best achieved in a merit selection process. And I don't think that there's much disagreement on this call with that position. And it's been a real uphill battle to get the decision makers in Pennsylvania government to come around to that. I think there is a movement coming around to that, but not enough yet that we have any immediate hope of getting that done. Really, the fundamental principle that underlies our judiciary is the principle of judicial independence, and that's embodied in Federalist 78, which talks about the purposes of the judiciary and what role the judiciary would play. And the founders had I think, a good insight into that, in that they provided for the appointment of judges for life. So if you're on the federal bench, you have a lifetime appointment. And other than wonderful job security, what that really does institutionally is protects a judge from public opinion. And you don't have to worry about being removed for an unpopular decision. And the founding fathers viewed the independence of the judiciary as one of the most important components of our new republic. The other thing that they did in framing the Constitution was provide that the compensation of a judge could not be reduced during his or her time in office. And obviously that's put in there to make sure that the Congress can't take a judge who ruled in a way that was unpopular and reduce the compensation. So it doesn't go up much, but it doesn't ever go down by act of the Congress. So I've now been retired from the judiciary for 2 years, and have quite a different perspective on that. I have many friends still in the judiciary, and the more I'm away from it, the more convinced I am of how important it is to have great people in those jobs. But this notion of judicial independence is not necessarily shared by everyone, particularly people in the legislative process. The states where judges are elected, and even some states where judges are appointed, there is a retention process. The Missouri plan for judicial selection provides for a merit selection by the governor, but then a retention election after 2 or 3 years of service. In Pennsylvania, we have retention elections every 10 years. And I can tell you from personal experience and from knowing so many people in the trial and appellate judiciary around the state, that judges are aware of what they're doing and what they're saying as their retention approaches. Should they be? No. Are they overly concerned? I don't think so. But they're mindful of the fact that they will be before the voters every 10 years in their career. Probably the most famous retention issue that I can recall was Justice Nigro, a very talented and respected justice of the Supreme Court, who lost a retention election after the pay raise was passed, and I think perhaps in reaction to how it was passed. But that was I think that was a move by the voters to send a message to the judiciary, which has very little to do with judicial independence. And why do we want judicial independence? Because the judges are the people who apply the law and interpret the law, and are to do so based on the facts that are developed in a case, the evidence that's in the case, and on the law as it's passed by the legislature and interpreted by the appellate courts. They shouldn't decide a case on who will be angry or who has power and influence, and who will contribute to an election campaign, or who did contribute to an election campaign. So the fundamental principle of judicial independence has to work a little harder in the environment of an elected judiciary. I think that the House Bill 196, which provides for districts to elect judges or appellate judges in Pennsylvania, really has more to do with judicial accountability than it has to do with judicial independence. And there's nothing in the Federalist Papers about judicial accountability. And that's a concept that has to do with a reaction by people who are unhappy with judicial decisions, that the judges should be accountable to the voters or accountable to the legislature, and that's I think that's a dangerous path to take. If we're looking at a truly three-part government, where the judiciary, which is the so-called quiet branch, which is supposed to do nothing other than to decide cases and controversies, is essentially passive in its approach, in the sense that it does not go out and seek and solve problems. It only decides cases brought to the courts, and does so on the basis of the law and precedent. And the popular response to judicial decisions is really not a factor, and shouldn't be a factor in the judicial decision-making process. So that's I think that's what's probably driving this. There is a sense that I think this is more of a smaller county, mid-state initiative driven by the sense that the appellate courts are populated by judges, mostly from the larger cities, Pittsburgh and Philadelphia. And whether that's true or not, right or wrong, I think that's one of the motivating factors. And there is a strong point there. I think there's an interest in diversity of several kinds. Certainly, our judicial election process does not provide for much diversity as to race, some as to gender, and some as to geographical distribution. The federal courts are far more diverse, and I think the only real way to accomplish diversity by gender and race is to use the merit selection process, and I think our circumstances in Pennsylvania are proof of that. And I think if you compare the federal judiciary with various state judiciaries, I suspect that that's something that you would find. So I don't have anything else to say by way of remarks. I'm happy to answer questions, and I look forward to a panel discussion, Pat.
Thank you very much, Judge Stengel. We do have a number of questions that have come in while the presentations were being made. Carol has joined us also as a panelist, and she will be also weighing in as we deal with some of these questions. There have been a number of them, I would say probably the majority as I scan through them kind of quickly, asking about what can be done to stop this, both in terms of political mobilization, and then secondly also in terms of a possible lawsuit. So I think we should field both of those separately. Now, at this point, Fair Districts PA has been focused on trying to stop it in the legislature, and that's where all of our energies will be put until it actually passes, and then we will probably, I would expect, join in with other efforts to convince the voters when they go to the polls that this is not a good idea. But Debbie, you may have more information about efforts because you have been working with other groups on this topic. Could you address that?
Sure, thank you. I think it's really important right now to contact your legislators. This really was pushed through without any kind of public hearing, input, comments from constituents. People didn't know it happened. Lawyers didn't know this happened. This was tried to get through exceedingly quickly. July 4th weekend, it'll happen again. It is proposed to be passed by the Senate the last week in January, the 25th week, and proposed to be passed by the House, and the Senate the first week in February. They need to hear from their constituents. Pennsylvanians for Modern Courts has some postcards. Write letters to the editor, write op-eds, as much information that can be submitted to your legislator, the better. They haven't heard from anybody other than the few bar associations, the trial lawyers, and PMC, Common Cause, but they need to be heard, from more constituents. With respect to litigation, as Pat said, it has not been filed yet. We hope that this could be stopped in the legislature. It may or may not be. I mean, I wouldn't bet on this. I'm not a betting person to begin with, but there is litigation being considered by various groups, by some legal nonprofits, by the trial lawyers. Everybody is looking at the statutes, whether the question is constitutional, but a determination, has not yet been made that a lawsuit or lawsuits will be filed. But should this pass, likelihood that's what will happen.
And if I may just follow up on that. I mean, there is precedent, if you will, for a constitutional amendment being approved by the General Assembly and by the voters, but that a lawsuit would be filed before it actually gets to the voters. So it doesn't get to the voters. It's passed by the General Assembly, but before it goes on the ballot, lawsuits in some prior efforts have been filed, and actually the question never got to the voters. So I think that's what you're referring to. Now, if it is approved by the voters, then there's a possibility of even further litigation after that before it would ever be implemented. And then, of course, once the legislature draws the districts, if we ever get to that point, then there's a further opportunity for litigation.
And the statute also has some interesting language where the General Assembly passes the laws or makes the determination as to the redistricting, but it has to be done with the advice and consent of the Supreme Court. And again, that's not clear what that means.
And we should also say, just to clarify for those who might have come late or who don't really understand how a constitutional amendment is passed, it has to pass in two consecutive sessions, the exact same language. So they can't amend it at this point. It's got to be the exact same language. It did pass in the last session. That's what we've been talking about. And as Debbie said, the plan is, that's already been decided behind closed doors, to pass it in the House and the Senate very soon. And I think somebody noted in the chat, it has to pass at least 3 months before the next election. So if the plan is to send it to referendum in the May primary, it's got to pass by the middle of February. So we just have a few weeks really to push back as hard as we can. The governor does not get to sign off on this. He doesn't get to veto it. The governor has nothing to say about the constitutional amendment. So this is an opportunity for citizens to reach out to their legislators to say, you may not, and we know that there were some Republicans last time around who voted against it. We want to thank them. We want to encourage them to stand firm and to vote against it again. And we want to encourage them to talk to their colleagues and remind their colleagues that this is a bad bill and it was pushed through fast, and maybe they made a mistake last time because they didn't have enough information, and we're happy to share more information. And that's part of what we need to be doing, is reaching out a lot and saying, please don't vote for this. Please don't give it a vote. Please stand firm against it. Please encourage your colleagues to stand against it as well. So right now we're in that citizen activism. There was a question about how do we prepare a winning campaign and how do we get money and funding and all that. I think there are many, many organizations that will be leaping in on this if it gets passed out of the legislature. There are not as many organizations that have a grassroots advocacy structure. And so there are organizations that have said, Fair Districts PA, you guys are the best at reaching out to your legislators. And we are the ones who really need to take a lead in doing that action right now. If it passes through the legislature, we probably won't be the ones taking the lead. We're not the ones with the deep pockets. And this has got very, very partisan. It will become a very partisan fight if it does pass. We probably won't be the ones leading that fight. We'll certainly be part of the effort to stop this in any way we can, but there will be a lot of money coming into this fight to block this bill.
I agree with all those comments. I think that the communication with legislators is really crucial. To a state senator or representative, the fact that a bill creates a constituency or a representative relationship is not really offensive, because that's what they do, and they feel that it's important that the various geographical areas of the state have representation on the appellate courts. That really does fly directly against this notion of judicial independence. That is, this notion of a constituency that to whom the judge answers or who elects the judge. And I think that the principle of a representational branch of government is not unusual or foreign to the legislators. And I think emphasizing the point about judicial independence and making sure, if you are opposed to it, that opposition is expressed. Because as Debbie said, it's appeared quickly, and there's not a lot of people who know that it's happening. I do think that a response to legislators would be really critical.
And I think another point that should be made about that is that, you know, a lot of the members are already on the record. You know, they voted for it once or they voted against it in the last time. They ought to be thinking, I mean, as they get more and more pressure from constituents and interest groups on this topic, they ought to be thinking about convincing their leaders not to move it. I mean, we've heard that they intend to do it, but the best way for an individual legislator to avoid, you know, having to take a position is to convince leadership not to bring it up again. It's not a foregone conclusion. I mean, there have been I can't even think of how many prior constitutional amendments that were proposed, passed in the first 2-year session, and never again saw the light of day. They never resurfaced. And it's still possible to make that happen, to make that a reality on this bill. It's just a matter of putting up enough pressure on the members. They don't want to take tough votes, and this is a tough vote, even if, you know, their legislative leaders tell them they should do it, or it's, you know, it's a good idea for whatever reason. If they can avoid a tough vote, that's usually their instinct. So we've had some other questions about, and Carol addressed the process, how this would come about and go before the voters. It really has to pass by the middle of February because it has to pass 90 days before the next election, which would be in the May primary. So that's the time frame. It's a little bit more than a month. They are not in, the House is not back in session. Well, they will be in session on the 11th, on Monday. The Senate doesn't come back until the end of January. So the action is going to be in the House first, most likely. And then the Senate will probably take up the, I mean, if they do pass it, the Senate will take up the House bill. There's also the possibility, and this didn't come up as a question, but I'll address it anyway, that they will follow a different process this time by attaching this bill to another constitutional amendment. And there is another one out there that passed in the last session and is on a fast track. We already know a fast track in this session. And that's the constitutional amendment to create a 2-year window for victims of child sexual abuse to sue the perpetrator even after their statute of limitation has expired. So a bill to create that 2-year window passed in the last session overwhelmingly. And it is going to be run through quickly and put, you know, an attempt to put it on the May primary ballot this time. So it is entirely possible that the judicial district bill will be attached to that bill, making it even more difficult to fight against. So that's something we all have to keep in mind, something we should probably be addressing with legislators. Don't do that. Keep these issues separate. I mean, the 2-year window received a lot of public scrutiny in the last session, public hearings, debate. The judicial district bill did not, and so it should not be, you know, attached to a bill that has had a lot of attention and public input. Does anyone care to address that before I?
The only other thing I wanted to add is that even though it would be attached to another bill, the question, okay, is still separate. So it would still be a separate question on the ballot. So which is important because the question also cannot be changed or the process has to start from scratch.
There was a question about the question, which is an interesting one. Who will write the language of the referendum? And that language sometimes is convoluted and confusing and can make people think, oh, this is a good thing when it's not a good thing. Who actually gets to write that language? Because that's pretty important in how this plays out.
Let me take that one, Carol, because very often the question is not contained within the bill. And so then it does have to be drafted and approved by the Attorney General and so forth. In this case, the question is contained within the bill. And I think that's actually raises some questions because in my opinion, the question does not adequately describe the bill or, you know, the constitutional change. For example, it leaves out entirely the fact that the legislature gets the opportunity to say that no judge or justice can seek retention election. The question doesn't make voters aware of that. The ballot question does not make voters aware of that. So, I mean, that's a potential basis for a challenge, I think, to the constitutional limit. So in this case, the question itself is put forward in the bill. So.
And Pat's entirely correct. You know, the question is in the bill. It is very unclear. It doesn't really explain things. That is a method of attacking this bill if we get to legislation, I mean, to litigation, the constitutionality of the question.
Another opportunity to try to influence the progress of this bill or the track that it's on is for members to offer amendments. Now, as Debbie said, if it's amended, then it has to go through another 2-year session. It has to pass in its amended form in this session and then go through another 2-year session. So for that reason, they'll say, well, we can't amend it. But I mean, that's not necessarily true. That's true only if you say, well, it has to be on the ballot in this year. We can't wait. It's that urgent. Well, of course, it's not that urgent, and it can be amended. And there are ways it can be, even though we oppose it in principle and on its merits. There are ways to quote unquote fix it or make it better. For example, the bill clearly gives the legislature the opportunity to pass a law that says that Supreme Court justices in particular, or maybe all justices and judges of the higher courts, may not seek retention, and they all have to run in these new districts. So an amendment could be offered to say, well, we don't want to throw out our current judges. Let's grandfather them. So that could be an amendment. Current judges and justices are grandfathered. They may seek retention at the end of their term. So that again, it forces the bill to have to pass another time, but enough legislators might think, well, that's a good amendment and it's a good idea. So that is an opportunity.
Just to point out, just a few more thoughts on strategy surrounding this and to answer a couple questions about how people can get information. The bill is House Bill 38. We will be sending an email to everybody who registered for this, and we've had about 500 people come on, but we have about 1,500 who registered. We'll be sending an email to all of them with a lot of links. So we'll have links to talking points. We'll have links to postcards that you can download from the Pennsylvania for Modern Courts website. We will have links to the vote, so you can actually look at the General Assembly votes the last time around and see who voted. There was a comment that's, I think, important to call attention to, which is this passed by just one vote in both House and Senate. I believe that's the case. It was a close vote, which means that there were Republicans who voted against it. And if we can convince a few more to vote against it, we can keep this from moving forward. But you will be receiving an email with lots of links. This video will be posted on YouTube. You'll get a link to that. It's also going to air on PCN. If I can get a link to, or at least the timing of when that's going to happen, you'll get a link with that information and links to various websites. There's also a request a speaker link on our Fair Districts PA website, and the link to request a speaker will be there. So if you want to request a speaker for your committee or your organization or your faith community, wherever you think it would be helpful to share this information, it has to happen soon. So our speakers are booking themselves pretty solid to share this information, to give information out. You also will be receiving a link to click through to send an email to your legislators. So that will be coming to you as well as talking points for making calls. The one thing I would say is if you have legislators that already oppose this, think about the leadership in the House and the Senate and contact them and say, please don't do this. Committee chairs and the leadership in both House and Senate to say, we strongly oppose this and we would really like you not to push this forward. And also, to give mercy to the Republicans who oppose this. They're in a tough spot. There are some wonderful Republican friends of our reform work who find themselves kind of hammered by parts of their party who are in safe gerrymandered districts who really don't answer to anybody, and that's a problem. We're seeing that a lot. But the leadership has an opportunity to stand up against it. The leadership has an opportunity to say, you know, we're going to protect those who are in difficult spaces, who are trying to do the right thing and listen to their constituents. And as Pat said, the best way to protect those folks is not to bring a difficult bill like this to a vote.
So the only thing I'd like to add is that I wouldn't assume that those who voted no on the Republican side will vote no again. They were given cover. They were maybe up for re-election. It was a safe no because they had enough votes, or they made a decision that they weren't going to run for re-election. There are a lot of different reasons. So, and there is a change in the legislature. So there are some new people. So we don't, nothing is known for sure. So I wouldn't make any assumptions as to who we know will vote in which direction.
One thing that I'd like to make folks aware of, when they do speak to their legislators, they're going to hear various justifications for the bill, and we've talked about some of them already. You know, we need to have representation and so forth. But another one you may hear, and we've heard it already, is that this is an opportunity for the legislature to deal with the problem of dark money coming into judicial campaigns, you know, outside interest groups spending so-called dark money to influence the election of judges on a statewide basis. And I think that what they're saying seems to be a couple things. One is that, you know, if you divide the state up into judicial districts, 31 of them, in fact, that those people with dark money will be less inclined to spend it in smaller districts, and or that the spending will have less influence because it will be, you know, in a district where there are other interest groups and there are other people involved in that race that will kind of somehow make the influence of dark money lessened. Anyone care to address that?
I actually think the opposite will happen because you won't have, you know, it won't be 5 judges up at the same time. The money can be targeted. We do have a problem with dark money. There was a great report by Spotlight PA in August 2020 about dark money, but you know, this election will not solve the dark money problem. That's a campaign finance reform answer or question. And yes, dark money is not good, but this will not resolve that.
The role of money in judicial elections has been increasing, and there's no, I don't think there's any reason to think that it will level off or decrease. So I think that there will be money involved behind judicial elections, whether they're in the current scheme or in districts. And I agree with Debbie. If anything, it might increase the role of money in this process.
In 2015, for our Supreme Court election, there was over $26 million raised. It was one of the highest raises for a Supreme Court election in the country. And that was for 3 spots. So the money is out there, and you know, and it's all, and now that it's now that everybody is more aware of Pennsylvania, right? We are a you know, a bullseye. We will be the target of money and dark money.
And I would also, again, to constituents who are meeting with their legislators or talking to them on the phone about this issue, and remind them that dark money is a problem in politics generally, in their own races, in the legislature, House and Senate. Dark money is prevalent. There are these groups that as Debbie alluded to, there was that investigation by Spotlight that talked about these groups that are kind of crossing the line or dancing on the line between being lobbyists and also being entities that run campaigns on behalf of legislators, and who are also connected with so-called dark money groups. And it's all very mysterious, and it's something that needs to be addressed much more broadly. It's not just an issue that relates to the courts. It's an issue across the board in our politics, and that's the way it needs to be dealt with. And of course, there are other ways to deal with the potential of dark money and affecting the judiciary, and merit selection, of course, being one of those. The nonpartisan elections is better than partisan elections when it comes to potential for undue influence of money and so forth. Public financing of judicial campaigns. And there are a number of ways to deal with that issue without saying, well, the only solution is regional districts. It certainly is not. Okay. Go
Pat,
ahead.
were you going to ask another question, or you want me to throw one in?
Please.
There was a question about just how many judges are we talking about? I mean, how often are appellate judges elected? I guess we could do the math, right? If there's 31, one of you can probably tell us how this works.
You actually can't do the math, in all honesty, because what happens if a judge decides not to run for retention? So, and the judges have to retire at, age 75 now. So it is unpredictable why a judge may decide to step down from the bench and go into, have a private life. But there isn't any rhyme or reason, it's based on when they were first, it is currently based on when they were first elected, right? But we don't know how this process will play out. We could have, I guess, a slate potentially of all the judges being offered up for election at the same time, the same year. But I can't imagine that, but I guess that's a possibility.
Well, I'd like to throw out another question, or at least a topic. And we have described this bill as judicial gerrymandering, or creating the possibility, the potential for judicial gerrymandering. And so, what do we mean by that? I think what we mean by that is that the bill, it allows the General Assembly to draw these districts, right? Using the same process that they use to draw congressional districts now, which is they pass a bill that describes the boundaries of the districts, and the governor gets to sign it or to veto. So the same process they have used in the past to gerrymander our congressional districts, some of the worst gerrymandering in the whole country, national experts would say. So the process is the same under this bill. The criteria that they would use in drawing those boundaries is the same, or are the same, as the criteria that they use to draw state house and senate districts that's contained in our Constitution right now, which is they must be compact and contiguous. They should not or must not divide counties, municipalities, et cetera, unless absolutely necessary, which sounds good, but has again resulted in some of the most gerrymandered state house and senate districts in the country. So when we say judicial gerrymandering, that's really what we're talking about. This is an open invitation to the legislature to draw these boundaries in a way that maximizes the possibility that candidates of their particular party will be elected. And I mean, can you imagine anything less, more unseemly, I guess, than the idea that members, Democrats, Republicans in the legislature are negotiating over the lines of districts that our judges are going to run in, and the governor has to step in and say, it goes too far in one direction or another. Debbie, you want to?
So I completely agree with what you're saying. Okay, I think if you want to make an impact on your representatives, I would not use that term necessarily, because that letter contact will be sort of tossed out the window, as they don't like gerrymandering, as we all know. And I would just use the term judicial redistricting. You may get more attention.
Judge, do you have an opinion on that?
You know,
Tiebreaker?
I think I think the setting of districts will be a second level of a political process. And so what are districts? You know, I think, you know, is it, do we divide the 67 counties into 7 regions for the Supreme Court? Are there different regions for the Superior Court? You know, is Center City one district and the Northeast another district? I mean, there's, you know, we do it by population. So I think there's a real opportunity for mischief in the setting of districts, and I wouldn't be surprised if there aren't long, narrow districts through the mid-state, so that somebody in York is who's supposedly accountable to the voters would be accountable to somebody up in the Poconos. You know, it's that could happen, and there's no plan in the legislation. So I think it's an administrative problem, and you know, that to get back to a point that we covered earlier, and I was thinking about you know, there is a way to involve people from the mid-state or the smaller counties, and that is to put pressure on or to request the statewide committees to look to the central Pennsylvania counties or the northern Pennsylvania counties. Many candidates come out of these regions where there's more campaign money and where there's more just politically active people with an interest in the judiciary. And I think at least for the appellate courts to make an effort to convince the Democratic statewide committee and the Republican statewide committee to consider geographical diversity. And I know it's hard to get people to run statewide sometimes, and I think the committees have to do some recruiting. But I think looking for people in the mid-state, looking for people of color, for women, you know, really could be a contribution and a responsible step by the committees in the existing process.
And I think if you look at the current makeup of the court, this bill is actually going to hurt counties. Dauphin County has 3 judges on the Commonwealth Court. That would never happen.
Right.
You know, so similarly, depending on how it's redistricted or whatever term we want to use, the collar counties to Philadelphia could lose their judges. So, you know, because the statute is so unclear and doesn't even consider these concepts, it is dangerous for all counties.
There's we're about to run out of time. There's one last question I do want to point to, which is people have asked, are there states that could serve as models? We don't have to reinvent the wheel. Aren't there states that have solved the problem of gerrymandering? Aren't there states that have solved the problem of campaign finance for judges? Aren't there states that have figured out how to create a more diverse judiciary? I think actually this has been answered in different ways. There are states that have merit selection and they have more diverse judiciaries. Really, the issue that we're talking about is in a state that doesn't have citizen initiative and referendum, where the legislature is not really interested in hearing citizens' voices, we can't look to those states. And one of the slides that I shared, Colorado has an agenda fairness score. It's a score of 100%. It's a state that has citizen initiative and referendum, but it also has open primaries. They've also solved campaign finance. They've also moved in many ways to make their elections more accessible and get more people to vote. And it's very easy to get a good bill passed in Colorado. There are some other states that have the same kind of legislative rules that let bills move through quickly. Pennsylvania is one of those states that we don't have any way. Actually, I was talking to somebody just yesterday about a lawsuit I would love to bring. Our Constitution says the people have the right to alter and reform their government. We have tried every way that we can to demonstrate that right, and we have not been successful. So yes, there are states that have solved this. And I would love to hear just a minute or two from Judge Stengel or Debbie about states that have done a stellar job in solving this. But we can't get there in Pennsylvania, given our current legislative structure, this current legislative rules, and the fact that we don't have citizen initiative.
Not aware of any state that has done regional districting for appellate courts. The states that have that have partisan elections are typically states that have significant problems from time to time with the quality of the appellate courts. If you look to our neighboring state of New Jersey, which has a form of merit selection, they have an outstanding state judiciary. And there are outstanding jurists in the Pennsylvania state judiciary, but there are also some periods in our history where some of the appellate courts have really struggled, and I think I don't take anything away from the men and women who serve now in the statewide judiciary. Many of them are just wonderful jurists and responsible and experienced and dedicated. But the state like New Jersey is well known for the quality of its state judiciary. And I think, Carol, that the way to resolve the money issues and the campaign finance issues is really to go to merit selection.
For those who are curious, the Brennan Center has a great website, is a great resource, has done studies, and charts of different states, different merit selection committees. I mean, it's a wonderful website and resource.
Well, thank you so much. I think we've come to the end of our time. It's been a great discussion. Thank you for the work that you did, Judge Stengel, upholding the law here in Pennsylvania. Thank you, Debbie, for what you're doing to call attention to how important the courts are and to find ways to address the challenges that our courts face. Thank you, Pat, for moderating, and thank you, Terrie, for introducing us. And thank you to all who, it's an exciting day, a lot going on. Democracy is having a pretty exciting, interesting time right now. And thank you for caring, and thank you for leveraging your own areas of influence to make Pennsylvania a better state and to strengthen our democracy. It's a lot of work. It's more work than we imagined when we started with Fair Districts PA, and the work just keeps getting harder. We keep learning more and more, but it will take many, many of us speaking out as strongly as we can, as clearly as we can to address this. I'm sorry we didn't get to all of your questions, but we will be sharing a lot of links and a lot of information, and pointing you toward more information in the email that you'll receive. So thank you so very, very much for being with us today, and let's continue the good fight together. Take care.
Thank you.